Oh, okay. There we are. Hello, everyone. I hope you're doing great. Let me go live on here on Instagram. Good afternoon, everyone. What did I do here? Okay. Oh my gosh. All right. Welcome, everybody, to this live video. We are about to get started. So please join in and share with your friends. We're going to have a discussion today and we'll have a question and answer session. We're live on Instagram, YouTube, LinkedIn, Facebook. We're trying to get on TikTok. So if you gave us a few minutes, we will soon be live on TikTok as well. Let me see. All right. Chris, Athena, are you on? Okay. All right, guys, please give us a couple minutes so that we can get connected on TikTok before we get started. How's everyone doing? Today we're going to be discussing one of the executive orders of President Trump. So please stay tuned and start sharing the live video. If you can hear me or see me, please just drop a comment. You can drop any comment, any emoji, any flag, US flag if you want, that's fine. Otherwise, any other emoji will do. And let me make sure that you guys can see me and hear me okay. Justine, I'm sorry, I think I have to take the number, the code here. You can come. Guys, hold on. Athena, I have the code. Yeah, hold on. So I'm live now. Let's see. The number is let me see here. Oh, it did send on here as well. 018
018
989.
89.
That work?
It says the code is incorrect.
Okay, let's go.
Sending another code.
No, hold on. There is a code here as well. 608522. I'm sorry, guys. We're trying to log on to TikTok.
There we go.
Okay, great. Thank you.
All right.
Excellent. Is it on? Okay, great. Oh, yeah. Thank God. So we can be live on TikTok as well. What did I do here? Okay. We go again. Let's get started. There you go. So we are live across our social media platforms. We're live on TikTok, on LinkedIn, on YouTube, Twitter. How's everyone doing? I hope you're all doing great. Let's get started because we have a lot to cover before we get into the questions of the day. I hope you guys can see me and hear me very well. Okay, now let me share my screen. We're going to be discussing the one of the executive orders. Let's see. Can you guys see me and hear me well? Miss Athena, please, can you shut my door? All right. Okay, so let's get into it, everyone. You're welcome to this live video. We are going to be discussing one major executive order that has caused a lot of worry to many people. Okay, let me take this off. And okay, so we're going to be discussing the executive order that is the basis of mass deportations. We'll discuss the executive order extensively. And then when we're done, we can answer questions. I aim to answer at least I aim to answer about 10 questions at least before we go off of here. So you can start dropping your questions, and then your question could be selected so that we can discuss it. Okay, so let's get started now. All right, so the executive order we're discussing today is called the Protecting the American People Against Invasion. And that's Executive Order 14159. So if you're on YouTube, Facebook, LinkedIn, you can see my screen. We have the executive order there where I've highlighted certain relevant portions. Instagram and TikTok don't have that, but if you want to see what's going on the executive order, feel free to join through Facebook, LinkedIn, YouTube. Okay, all right. So this executive order is the one causing the mass deportations, pretty much. Okay, the president wants to protect Americans against invasion. He's saying there's invasion of the country, there's aliens. That's what the Immigration and Nationality Act calls people who are not from the United States, or people who are non-citizens. It calls us aliens. Well, it calls immigrants who are non-citizens aliens. Okay, so it calls immigrants aliens. It's quite a derogatory term because it's just it just really excludes certain people from the realm of human beings. But that's what we are called, aliens, immigrants, pretty much. Okay, so what is the purpose of this executive order protecting the American people against invasion? The president says that over the last 4 years, the prior administration has overseen a flood of illegal immigration into the US. So millions of illegal or undocumented immigrants have crossed, and they've been permitted to settle in American communities. And the president Trump is saying that this is in violation of long-standing federal laws. Okay, this is violating long-standing federal laws, and so there have been a lot of these undocumented immigrants who have been or who have presented significant threats to national security and public safety. They've committed a lot of acts, according to the executive order, heinous acts against innocent Americans. And some are involved in hostile activities, economic espionage, and some other very negative, derogatory things against Americans. Okay, let's move down. Let's move down and let's see what's going on. So that is the purpose of this executive order. And furthermore, the purpose is saying that the government or the president of the United States is saying that American people deserve a federal government that will prioritize their interests and understands that they have to prioritize the safety, security, and financial economic well-being of Americans. So this order is going to ensure that the government actually faithfully executes the immigration laws of the United States. Again, this is what every president seeks to do, right? Prioritize their nationals. Okay, so that's the purpose of this executive order. Now, what's the policy? The policy of this executive order is that they want to faithfully execute immigration laws against all, number one, inadmissible immigrants, deportable or removable immigrants, particularly those who threaten the safety or security of the American people. Okay, all right. They want to achieve, enforcement of the laws through lawful incentives and detention capabilities. All right. Now they are going to faithfully, Section 3 of the executive order says that they're going to faithfully execute immigration laws. But it seems like so far, some of these deportations going on have not necessarily faithfully executed U.S. immigration laws, because there have been some laws that have been sidestepped. Okay. All right. The next thing we're doing is let's take a look at this Section 3B. The executive order states that executive departments and agencies, they must take all appropriate action to revoke all memoranda, guidance, or other policies based on some of the executive orders that were instituted by former President Biden. And if you look at one of the executive orders that have been revoked by President Biden, restoring faith in our legal immigration system, it actually talked about allowing more immigrants to become US citizens, allowing them to settle, welcoming immigrants. And this executive order has revoked all those orders by President Biden, which attempted to welcome welcome immigrants into the United States. Now let's go to Section 4 of the executive order, which talks about civil enforcement priorities. Okay, civil enforcement priorities. The executive order is directing the Secretary of Homeland Security to take all appropriate action to enable the Director of USCIS, CBP, and Director of USCIS to set priorities for their agencies that will protect public safety. So every government that comes has enforcement priorities. President Biden's enforcement priority was people who were a threat to national security, who were criminal threats or a threat to the safety of communities who had criminal records, and third, people who were a threat to border security. So this executive order is asking these agencies to determine what the priorities or to set priorities in order to protect public safety of Americans. Then they also have this criminal enforcement priorities. So I'll say that civil enforcement priority has more to do with prioritizing the safety of the nation by making sure that deportations or apprehensions are done against people who have violated US immigration laws. Criminal enforcement priorities targets people who have criminal records. It prioritizes the prosecution of criminal offenses related to the unlawful entry or the people who are continuously in the US unlawfully. Okay. Section 7 of this executive order talks about the identification of unregistered, undocumented immigrants. And I discussed this in some videos that we shared. The government or the president wants to make sure that all unregistered non-citizens or foreign nationals in the United States are registered. Okay, they have to be registered in accordance with law. And so we're going to see what that will look like within the next few coming weeks or months. And if you don't register as a non-citizen, then you could face civil penalties and some fines. You pay some money. So it's very interesting. We're going to see what kind of order that's going to be soon. Now, efficient removals of recent entrants and other aliens. That's what Section 9 of the executive order talks about. And it says that they're going to promptly take appropriate action to remove non-citizens through section, they can use Section 238, 240 of the Immigration and Nationality Act. And the purpose of this is to ensure that there is efficient and expedited removal of non-citizens from the United States. We've already started seeing some of this. There's a lot of expedited removals going on where people are deported without being allowed to appear in front of an immigration judge. Okay. All right, let's keep going. Detention facilities, the Secretary of Homeland Security, what they're saying is that the president is going to take appropriate action to allocate available resources. The Secretary of Homeland Security is the one that will allocate resources, and they'll have to establish contracts to build or use facilities as detention centers. So people who are deportable, DHS is going to come up with, tents, detention camps. They'll build centers or use facilities that are available to detain removable people who should be removed from the US or who are supposed to be deported. These people are the people who obviously have prior removal orders. They've been ordered deported in the past and didn't leave for some reason, and the people who are a threat to national security. So we're going to see them come up with, building of detention, more detention facilities to house immigrants. If you guys are aware, we shared news on the fact that some of the detention facilities are releasing people from, from detention because there's not much space. The beds are limited, spaces are limited, so they want to build more detention centers. Now, Section 11 of the executive order talks about the federal-state agreement. This is where the government is saying that state and local enforcement agencies must assist with, or they can assist with, the protection of American people. This means that the local police, your sheriffs, your county police, all these local enforcement, the people that help with the making sure that there's peace in your local communities and neighborhoods, they are going to join in the investigation, apprehension, detention of aliens. Okay, so it specifically states that these people should start performing the functions of immigration officers. Now, the executive order says that, the executive order is aware that there is a separation between state and the federal government. And so it says that to the maximum extent possible, permitted by law and with the consent of the state or local officials, they'll take appropriate action to perform the functions of immigration officers in relation to investigation, apprehension, or detention of immigrants in the U.S. Okay, so that's what you're going to be seeing, a collaboration between the local police and the federal police. And the major problem with this is the mistrust that is likely to breed within our communities, right? Because if an undocumented person has some type of problem, maybe somebody commits a crime against an undocumented person in their neighborhood, there's some robbery, and an undocumented person is a witness to the robbery. Let's say the undocumented person went into 7-Eleven or a gas station to buy some snacks. And when they got there, somebody entered, a robber entered at gunpoint, and then maybe shot the person who was behind the register. And then the robber just fled out of fear, ran out. If there was an undocumented person who was hiding in the aisles and saw everything, what this executive order is going to do is it's likely to prevent that undocumented person from calling the police to get the person who was shot help. That person could be a US citizen, because if I call the police, local police, and they're supposed to be cooperating with ICE, they're going to question me. They're likely going to ask me what my status is, or they could call ICE later down the line, or they are going to verify what my status is and then hand me over to ICE. So if I know that that's a danger, then I am likely to leave to protect myself, right? I'm not going to call the police if I know that there's a cooperation between our local police and ICE. So these are some of the problems that this is likely to breed by encouraging the cooperation between local police and ICE. And then the executive order continues to say that it's going to encourage voluntary compliance with the law. Secretary of Homeland Security will take appropriate action to adopt policies and procedures to encourage undocumented people who are unlawfully in the States to voluntarily depart, to voluntarily depart the US. And that's what they've been trying to do. There, if you guys have been following what's going on, the White House just released about 2 advertisements, one for international consumers and one for the people in the US. And they're telling undocumented people to leave. Otherwise, they're going to be forcefully removed from the United States. It's a warning telling them that they're not welcome here. If you're a criminal, you're not welcome. Even if you're not a criminal and you are here, don't have lawful presence, then it's saying that you're not welcome here. So these are already being implemented as the executive order directs. But they are not necessarily encouraging voluntary compliance. They are issuing threats and warnings so that people will be afraid and then self-deport from the United States. Section 13 talks about recalcitrant countries. These are countries that refuse to take their nationals back. As you guys know, when it comes to deportation, the people who are not stateless, many people are not stateless. Many people come from countries. Undocumented immigrants come from countries. They could come from countries in Africa, in Asia, in Europe, wherever. And so if you have undocumented immigrants who are from Nigeria, Kenya, Ghana, ICE is going to work with the embassies of these countries in DC or wherever they are located. Usually they have the headquarters or their main embassies in DC. And ICE is going to work with them. ICE will provide them with a list and say, okay, can you verify that these people are nationals of your country? If they are, prepare travel documents, and then we'll buy their tickets, and then we can take them back to their home countries. And when these people are being deported, they are usually handcuffed and they are taken straight from detention into the plane. You'll not have the chance to go home and pack your bags and go and take money from the bank. So if a country is recalcitrant, it means that they usually provide a harder time for ICE. They will not confirm that particular people on the list are Ghanaians or Nigerians, or sometimes they don't produce the travel documents for these people, and this delays the deportation process. ICE is saying that if there's a stubborn country or a recalcitrant country, they are going to face sanctions from the United States based on this executive order. Okay. All right. The next section of the executive order talks about the fact that they're going to eliminate documentary barriers, dilatory tactics, and other restrictions that prevent prompt repatriation of undocumented immigrants into any foreign state. If there's a delay, then there will be sanctions to those countries. That will be meted out to those countries. So they are interested in eliminating all barriers, dilatory tactics. If there's any, you're doing any delay tactics. If you need to accept 100 people are from Ghana that need to be deported, what the executive order is saying that they will give the Ghana embassy some time within which these people have to be issued with travel documents so that they can deport them. If there's delay tactics, then Ghana will face sanctions or Nigeria will face sanctions, whichever country that plays these delay tactics. The Section 15 talks about the reestablishment of the Voice Office addressing victims of crimes committed by undocumented immigrants. They are going to reestablish the office that in the past provided professional services to victims of crimes committed by undocumented immigrants. So if a crime is committed by an undocumented immigrant, let's say rape or some other crime, then Voice was a service, a professional service that took care of the victims of these crimes. So these victims are usually US citizens or people who had status and who needed assistance from the government. Okay, so let's go on to Section 16. All right, the executive order says that the government is rescinding, addressing actions by the previous administration. Secretary of State, AG, Secretary of Homeland Security, they are, rescinding policy decisions of the previous administration that led to increased presence of undocumented immigrants. So we've already started seeing some of these things. The parole programs are being eliminated. TPS designations are being, there's no more extensions. Asylum ban. The main thing is really sealing the borders, the southern border, and then also rescinding the policy decisions that allowed some people to enter the US on parole or some type of temporary status. Okay. Yeah, they re-emphasize that parole is supposed to be exercised on a case-by-case basis, not on a whole-scale basis like Biden did. Even with Biden, even though it was granted to countries, the cases were still reviewed on a case by case basis, but it's saying, okay, revoke all these things. And we've started seeing some of these things happening already. Then it goes on to say that designations of TPS should be consistent with provisions of law, meaning they should be temporary. If you saw Christy Holmes, is that her name? She has been saying that temporary protected status is going back to temporary. So they're already declining to extend TPS. TPS is for, people who are from countries which have an arrest or some, issues that make it unsafe for the nationals to go back to those countries. So the US says, okay, we're giving you safety from deportation, stay here. And then, we give you some 2 years, you can get a work permit, work, rebuild your life, and then you can attempt to get a green card while you're here. Or if you don't have status after the 2 years, we give you TPS. If TPS ends, then you can leave. Okay, many people don't leave after that TPS status ends. Now, Section 16C is stating that the executive order has to ensure that EADs or employment authorizations are provided in a manner consistent with law and not provided to undocumented immigrants in the United States. We already see that there's before former President Biden left office, what he did was to codify the 540 automatic day extension for timely filed EAD renewals, I believe, and EADs. Now there's a challenge to that final rule. They are challenging the final rule that has been codified, and so we'll wait to see what the policy memo or the guidance will come up on of employment authorizations. Perhaps the government may, or President Trump may say, okay, some people should not be issued with work authorization. He may narrow down the number of people or the categories of people who may be entitled to work authorization. And I'm very interested in finding out what this looks like, because the problem is that undocumented people, many of them are here to really work and earn a living. And sometimes they just fall out of status through no fault of theirs, right? So if they're here and their work, their ability to work is taken away from them, then you can imagine what that's going to do for our, communities and societies. I hope it does not get to that, but we'll see within the next few coming weeks what that looks like in terms of execution. Because the executive order says that, they should not provide employment authorization to undocumented immigrants in the US. So that could cause a lot of people to get involved in things they should not get involved in just to survive. Okay, so Section 17 talks about sanctuary cities or sanctuary jurisdictions. As you guys know, sanctuary jurisdictions are those that limit cooperation between the local police and ICE. Okay, so if you are in New York, which is a known sanctuary state, and you commit a crime, then New York police will usually not send your name over to ICE if you are undocumented, or share information with ICE and say, come pick this person up. They just do their work as local police, and if they don't have to detain an undocumented immigrant, they don't. Some of the states that are not sanctuary jurisdictions, what they do is they'll cooperate with ICE, and then ICE will pick up the undocumented immigrants and put them in detention. Sometimes the crimes that these people have committed will lead to mandatory detention, meaning they cannot leave until they're done with their immigration proceedings. So this executive order is saying that there will be, it says that they'll evaluate and undertake any lawful actions to ensure that so-called sanctuary jurisdictions seeking to interfere with lawful exercise of federal law enforcement, they don't get access to federal funds. So they're going to punish them financially. These states will not get access to federal funds. Okay. And so many sanctuary jurisdictions are likely to buckle under this pressure. information sharing under section 18. Let me see how much more we have. Okay, we're almost there. Where it ends at section 23 and we are at section 18. Okay. Section 18 of the executive order says that information sharing, the Secretary of Homeland Security, they shall promptly issue guidance to ensure that there is maximum compliance by DHS personnel with provisions of law, and ensure that state and local governments are provided with the information necessary to fulfill law enforcement, citizenship, or immigration status verifications requirements authorized by law. So what this section is saying is that Secretary of Homeland Security or DHS, they have to make sure that the state and local police or government, they have to have access to what they need to be able to easily verify immigration status. So if you are arrested by your local police or you're stopped on the road for maybe overspeeding, there should be some sort of database or some immigration status verification that the local police or local sheriff or whoever can run and determine that, oh, you are here in violation of immigration laws, and then they can tell ICE that, oh, we have somebody for you. This has not been happening, but Section 8 of this executive order says that there must be information sharing moving forward to ensure that there's that is available to the state and local governments to help fulfill immigration enforcement, okay? Carry out immigration enforcement. Okay, now funding review, this section 19, it talks about the fact that, you know, they are going to immediately review and audit contracts, grants, or agreements which provides federal funding to non-governmental organizations that support or provide services to undocumented immigrants. And as you guys know, just yesterday, President Trump signed an executive order stating that all federal help that's being given to undocumented immigrants cease immediately. So this executive order is also already happening. What the executive order is saying is that they want to ensure that the resources of the U.S. are free of waste, fraud, and abuse, and that the federal government is not promoting or facilitating violations of U.S. immigration laws. Because they're saying, well, if these people are here and they shouldn't be here, and you are giving them help or aid, whether it's in the form of some food assistance, medical assistance, housing assistance, or unemployment assistance, or whatever, they don't want to be seen to incentivize people who are here undocumented. The executive order under Section 18 also says it must pause distribution of all further funds pursuant to, these are such agreements, and then they must terminate all such agreements determined to be in violation of law or to be sources of waste, fraud, and abuse. Okay, let's go to Section 13, denial of public benefits to undocumented immigrants. It says illegal aliens. The director of the Office of Management and Budget will take appropriate action to ensure that agencies, they will identify and stop the provision of any public benefits to any undocumented immigrant who's not authorized to receive them under the provisions of law. Okay. And then Section 21, it says they're going to hire more agents and officers. So they're going to hire more officers and agents for USCIS, CBP, so that they'll significantly increase the number of agents and officers available to perform deportation, arrests, interviews, enforcement actions, duties of immigration officers, which include enforcement actions. But what we're seeing is people are rather being fired. So I don't know if the strategy of the government is to first purge the government agencies of all former President Biden's appointees, and then they will reappoint their own people. But they intend to hire more agents and officers who can carry out these enforcement actions. All right, so we are done here with the review of the executive order. Okay, let's go. All right, so we're going to be taking questions now. We'll take some questions from you if you have a question or concern. we will, okay, let's take this off, and then we can start with any questions that we have. Please drop your questions and I will be reading or reviewing them here. Let's see. Okay, so we have a lot of questions. Let me see if I can pick one and then we can go with it. All right. Okay, so Ifwa Naki Okan says, I think I missed the point. Are you saying they aren't giving out work authorizations anymore? No, I didn't say they're not giving out work authorizations anymore. Let me go back to the executive order so you see exactly what it says. It just says they're going to review who should be entitled to work authorizations. Let me see if I'll find it. It must be in this section. Let's see here. So the government or President Trump just wants them to review who is entitled to work authorization. Currently, if you enter the US and you are undocumented, and let's say you apply for a green card, let's say you came in on a visitor's visa 10 years ago and you've overstayed and you get married to a US citizen and you apply for a green card, usually you will be entitled to apply for work authorization also. If you also have, if you have an asylum case pending in court, for example, you can also apply for work permits. A lot of the applications that you submit to the government in order to get an immigration benefit, they allow you to apply for work authorization while you are waiting for your case to be decided. You're waiting for your case to be decided. And the executive order says that they're going to review who gets work permits, and they don't want undocumented immigrants to get work permits. So again, remember the executive order. A lot of the times, I'm struggling to find the exact section of law that the exact section of the executive order that I'm looking for. But a lot of the times, these executive orders, they will give, the broad policy, and then there will be policy guidance, memoranda that will be implemented or issued later to conform with the executive order or to ensure that the executive order is carried out. Okay, there you go. So it's under section 16 of the executive order. It says that they want to ensure that employment authorization is provided in a manner consistent with law, and that employment authorization is not provided to any unauthorized alien in the United States. So nothing has been implemented yet, but we are waiting to see how this is going to be implemented very soon. Okay, I'm going to take another question. Let's see here. Let me see if I can share my screen here. Okay, so there was a final rule that was published on December 2024. That final rule increased the automatic extension period of employment authorization or work permits for some people. So the rule was, it was codified in law to permanently increase the automatic extension period for people who had their work authorization expiring. It increased it to 540 days. That's how many years? Maybe 5 years, 5 additional years. And this increase was available to, or is available to, some renewal applicants. If you timely file, so if before your work authorization expires, you file a timely renewal of your work authorization, then you will be issued with a 540-day extension. And this was supposed to help bridge the gap between, or just help cure gaps in employment, right? Because some people would be laid off if they didn't have valid authorization. And the USCIS was so backlogged that they wanted some time to be able to process the cases. So if you filed a timely renewal of your work permits, then they'll send you a receipt notice that would extend automatically your work permits for an additional 540 days. And this has become a final rule, but I see that they're trying to challenge it. A couple of days ago, there's been a challenge so far, but we'll see what happens with that. It's not finalized yet. So it's not saying that they shouldn't issue work permits. They will issue work permits, but they are likely going to narrow down the scope of people who are entitled to, or who are eligible for work permits under law, or even the extensions. What is going to be the validity period of work permits? Okay. Now let me see if there's another question. Okay, Steve Kenfax says, how can I get you for counseling? Okay, yes, you can contact us for consultation. It's right there on your screen. That's how to contact us, or Google AK Pokulo and you'll find us. Let me see if we have more questions here. Let's see on Instagram if we have some questions on Instagram. Okay, so we have a question on Instagram that says, by Grey Cards 09, the person said, please, is it possible to change status from B2 to F1 looking at the current situation? You can absolutely change status from B2 to F1. You can do that. It's called a change of status. If you are trying to change status from B2 to a green card holder or to green card, it's called an adjustment of status. This change of status process exists, and you need to file a timely change of status. This has to be done 45 days before your I-94 expires, or as soon as you know that you need to change status. But this is a very tricky process because generally USCIS does not like people to come into the US on a B2 visitors visa. You said you're coming to visit, and the next thing they know, you have an I-20 and you're trying to change status without leaving. They see this as trying to probably circumvent the law, and they, generally they don't like it too much. And for people that do that, they could ask questions like, okay, when did you actually get admission to the school? When did you know? Because if you already had admission before you entered on a B2 visa, then it's a problem, right? Because the purpose of a B2 visa is for tourism. And so if you take a visa and you are entering, you have to enter with the intent to pursue the purpose for which the visa was obtained. And if you enter with a B2 visa with the intention to come to school, when you know that, to come to school, you need an F visa, a different type of visa, then it's called fraudulent intent. So they can probe or look into these things because they don't want people to circumvent the law. So it's usually better to go back to your country and apply for an F visa from the consulate. But we've handled several cases where we filed change of status from B2 to F1, but we look at a lot of factors and then we advise accordingly whether we will recommend it or not, to avoid the possibility of USCIS blaming you for a fraudulent intent at the time of your entry into the United States. Okay, let's see if we have a lot of questions. I'm trying to scroll through them. Let's see if I can get something on TikTok. Somebody says, N600, please, how can I file for N600 without attaching my father's citizenship certificate? So the N600 is the certificate of naturalization for children who have derived US citizenship Usually they enter the United States. Let me start by saying that you can obtain US citizenship through a variety of means. We have automatic acquisition of US citizenship. You are born in the United States. What Trump is trying to, undo, birthright citizenship, born on US soil, you become a US citizen. That's called automatic acquisition of US citizenship. Then we also have, and that's jus soli. Then we also have automatic acquisition by being the child of a US citizen parent. For example, we'll look at physical presence rules and all those things, whether father has met physical presence rule of 5 years before you were born. If you were born outside the United States, okay, you can automatically acquire US citizenship if you were born outside the US. If your father meets certain physical presence rule, or your mother meets some of these physical presence rule, if they are US citizens, then you can apply for something called a CRIBA, Consular Reports of Birth Abroad. Now, the second way is through derivation of US citizenship. Through that means if your father became a US citizen after you were born, maybe through the process of naturalization, then, for example, dad can apply for a lawful permanent resident for you. You will come into the US as a lawful permanent resident. And if you show that you are living in the legal and physical custody of your dad while you were under the age of 18, then you can be said to derive US citizenship, so you can apply for the N600. So as part of the process, we have to show that your dad is a US citizen, and there's some other requirements. So please contact us so that we can help you with that particular inquiry, because the N600 usually have just one chance to apply, and once it's denied, you cannot file. You usually have just one chance to apply. I believe there's no appeal process with that. So make sure that you do the right thing, and we can help you ensure let me just, okay, we're going to look at another question. Let's see here. I'm trying to find this. Okay, so please contact us and let's see how we can help you there. Let's see if we have another question. Nasika says, can a 10-year marriage-based green card holder travel outside the United States? Okay, so if you are a 10-year, you have a 10-year green card, you can travel outside the United States. So there are two types of green card holders: 10-year green card holders or lawful permanent residents, and we have the conditional residents who are 2-year green card holders. For those people, they have to remove the conditions before they can get a 10-year green card. For 10-year green card holders, it means that your case was approved after you had been married for 2 years, or you removed the conditions on your 2-year green card and then got a 10-year green card. A green card allows you to work and travel internationally, work in the United States, travel internationally as well. With the current issues that are going on, I would recommend that if you're a lawful permanent resident and you have a criminal record or some type of taint on your green card, like there's some issue, if you travel, you are likely to be pulled in secondary inspection. Okay, you are likely to be put in secondary inspection if you have a criminal record or some type of issue with your green card. So I don't recommend that you travel if you have some issue with your green card. Now, if you travel also on a green card, you should make sure that you don't stay outside for more than 180 days. Because if you do stay outside for more than 180 days, when you're coming back in, you will be a candidate for admission. The government, you're seeking admission, just like somebody who's coming on a B2 visa. But if you're coming in and it's less than 180 days, then you will not be seeking admission. You'll be admitted. Because if you're coming in as a lawful permanent resident and you've stayed out for more than 180 days, then it's presumed that, or there's a rebuttable presumption that, you've broken your residency, or you're trying to abandon your residency. If you stayed outside the US for more than a year, then you are deemed to have abandoned your permanent residency. More than 6 months, it's like it's a rebuttable presumption, meaning you can bring evidence to that, oh no, I did not abandon my permanent residency. And yeah. Okay, so yeah, you should make sure that if you travel, you're coming back in within 180 days. And if you can avoid travel until we figure out what's going on at the different ports of entries, that would be best, because we're seeing lots of travel advisories concerning green card holders that are being detained, and green card holders that are being forced to sign the I-407 record of abandonment of the lawful permanent residency. Okay. All right, let me see if there are more questions. I'm trying to see if I can see some questions that we can use. Okay. Yeah, I think I found what I was looking for. With the N600, if your N600 case is denied under Section INA Section 320, and you fail to submit a timely appeal of the decision, then USCIS will reject any other application for a certificate of citizenship. And they'll say that you should rather submit a motion to reopen or reconsider. So, the chances there are usually very limited. So you make sure you submit a very good case for the N600. That's what I was looking for. Also, let me see if I can find some more questions on some of these other platforms. Let's see. On TikTok, user says, hello, at what point should one sue USCIS when the case is outside processing times for over 6 months? It depends. Anything that's an unreasonable delay, you can sue, but it depends on where you live and how the courts are interpreting a reasonable delay. So please contact us so we can look into your case some more and determine what the best course of action, whether a mandamus, which is a suit against the federal government compelling them to take action in your case. It's a procedural tool that will compel the government to act on your case or give a decision on your case. So unreasonable delay depends. It depends on the case type. For something like an asylum, a 3-year period may not necessarily be unreasonable. But if it's another case type, which should take less time, then that could be unreasonable. So it's a matter of fact. So please give us a call and let's see how we can help you there. Okay. Let's see here. Miss Kabuki also on Instagram says Trump promised to give all international students green cards after graduation. Have you heard anything on that, please? Okay, so I mean, listen, politicians will always be politicians. He made one promise. We remain to see, we are waiting to see whether he can faithfully execute that promise. But he has bigger fish to fry. So he's more concerned with mass deportation at this time. That is his number one obsession, mass deportation. And so until the numbers, he's happy with the numbers, I don't see him trying to give international students green card at this time. We could be surprised within the next few coming months. They could make a case, to see whether international students could be granted green cards, but there's just no policy yet on this. Okay. Let's see here. We have, let me see on TikTok if there's more questions here. Otherwise, we're going to call it a day. Looks like we're really right on time. Oh my goodness, 1:30. Okay, somebody says Car Kits Africa. Car Kit Africa. She said how many change of status applications can be filed by an individual. The law doesn't tell us that there's a limit to this, but you don't want to be known as a notorious change of status person, right? Like just be changing status. In order for you to successfully change your status, you must be in status to change status. Okay, so let's say you came in on a B2 visa, you have an I-94. I-94 is a period of authorized stay. When you are entering the United States, CBP will let you know how long you can stay. If they don't let you know when you come in, please verify where your I-94 is digitally on CBP website to know exactly how much time you were issued. Initially, they were stamping passports. Now they're doing the paperless entry. So your passport may not be stamped with how long you should stay. So verify on the CBP website. Okay, now once you come in, let's say you've been given 6 months, and in your third month, you apply to a school in, let's say, Cornell or Harvard or Georgetown, and Georgetown accepts you. You have an I-20. You can apply for a change of status before your period of authorized stay 6 months is over. Now, if you don't do this before your I-94 expires, then you could do something called a nunc-pro-tunc, NPT, or a nunc-pro-tunc is Latin, that means then for now. So you should have filed it timely. The change of status must have been filed before your I-94 expired. But if for some reason, circumstances beyond your control, you couldn't do it, maybe you were sick, maybe something happened, you can ask the government to review your application as though you had submitted it when you had to submit it. So you can file a change of status from B2 to F1. And then while you're still in school, you can file from F1 to H1B if you get an employer that wants you to work for them. And while you're doing H1B, you can file another change of status to F1, and you can file a change of status to another non-immigrant. So the law doesn't tell us there's a limit per se, but if you do have a particular question or situation, give us a call and let's see what we can do in that situation as well. Okay. All right, Mami Abuna Chamanting, thank you so much for watching. Appreciate it so much. If you're an international student graduating, want to change your status, what to advise? You don't have a job yet. It depends. It depends. It depends on timelines. If you have OPT, if you're an international student graduating in May, you want to change status. Listen, you have to do what you have to do. For some people, I do have clients who are currently doing PhD because, they want to study and it's like, okay, there's no other option. So it's up to you. If you have OPT, a year of OPT, you want to take advantage of that. If you're doing STEM, then you have an additional 2 years of STEM OPT. So 3 years. And during the time, you can try EB2NIW, you can try to get an H1B, you can try EB3, you can try to go back to school, or if you meet somebody you fall in love with, then you can file an adjustment to get married. So there are a few options there. But as I tell my clients, there's not like 101 ways to get a green card. The ways are very limited. So it's not about finding 200 ways to get a green card. The few ways you have, it's about just because you're going to go through just one door, right? It's just like having a huge mansion with 30 beds. You don't need 30 beds to sleep at night. You just need one bed. And even on the bed, you're just going to sleep on one little portion. So you don't need 1,002 ways to get a green card. Just pick one viable method and maximize it, utilize it well. And that's the problem of many people. They are looking for 50 ways to get a green card. You don't need it. You just need one. If you have that one and you understand what you're doing and how you are doing it, that's all. You do it well, you do it good, you are good to go. Okay, so don't worry about trying to get so many methods of regularizing your status. Find one route and then go through it. Obviously, if you have two two ways to regularize. That's great. Some of our clients, they could have, one spouse is on H1B, another, has an approved EB2, and they're in F status. The H1B employer says they'll file at the end of the third year. EB2, it's approved. They're waiting for priority days to become current, and they apply for a green card. So, wife gets a green card on his own merit, husband gets a green card. That's great, right? You can always have a backup plan, but you only just need one route that works. Okay. Abuna Baby says that can a child get a green card if she has overstayed her visitor's visa when one of her parents is a US citizen? Okay, absolutely. So let me explain by saying that there are some people who are called immediate relatives. Okay, immediate relatives are people, no matter how long you've overstayed, the law forgives your overstay. So if you are an immediate relative, you are the spouse of a US citizen, you are the parent of a US citizen, or you are the minor child of a US citizen, for those people, overstays are generally forgiven. So it doesn't matter if you've overstayed for 20 years, 100 years. Hold on, I'm on live video. Okay, so it doesn't matter how long you've overstayed your visa, you will be forgiven. So if a child has a parent who is a US citizen and the child has overstayed, let's say the child came in on a B2 visa, they've overstayed, the child can regularize their status. USCIS or the government will forgive their overstay because they are known as immediate relatives and they're entitled to get green cards even if they've overstayed for 100 years. We've worked on several of those cases. A parent will come into the US, they'll come in on a visa, let's say B2 visa, they came in 35 years ago. They gave birth to a child, the child is now 21 years old. They've overstayed their visa 30 years. We get green cards for those people all the time. If it's a child also, you can get a green card for the child even if they've overstayed. And the good thing about being under the age of 18 is that the child does not begin to accrue unlawful presence until they turn 18. You see, so if you are in the US and you overstay, there's a clock that's ticking, a legal clock, and that's called accrual of unlawful presence. There's a difference between being out of status and accruing unlawful presence. The child under 18 will be out of status, but they do not start accruing unlawful presence until they turn 18. If you overstay your period of authorized stay for more than 180 days but less than 1 year, you leave the United States, you have a ban of 3 years. You've accrued unlawful presence of 180 days. If you accrue unlawful presence of more than 1 year and you leave the US, then you trigger a ban of 10 years. You cannot come back into the US for 10 years. So unlawful presence is relevant for purposes of determining who is barred when they're coming back into the United States. So the child who's 18 years old, they don't accrue unlawful presence. So even if they leave, they will not necessarily face a bar or a ban from coming back into the US that other adults could face. Okay, but yes, a child can get a green card even if they've overstayed because they are known as immediate relatives. You can compare or contrast. So there's two types of people. We have immediate relatives and we have preference immigrants categories. Preference immigrants categories covers, adult and married children of US citizens. Those are the F1 category. So if you are the son or the daughter who's unmarried of a US citizen, you are F1. Those people, if they're in the US and they overstay their visa, they cannot adjust or get green cards in the US. They would have to leave the US in order to get a green card. F2A, that is the minor children of green card holders or spouses of green card holders. F2B, they are also preference immigrants categories, adult and married children of green card holders. That's unmarried son, unmarried daughter, above 21 years old. We have F3, who are the married children of US citizens, and we have F4, siblings of US citizens. Okay, those people are preference immigrant category, And for those people, an overstay can affect their ability to get a green card without leaving the US. For immediate relatives, overstays are forgiven. Spouses of US citizens, minor children of US citizens, parents of US citizens. So for those people, they're usually good to go even if they overstay. All right, guys. I think we've done as many questions as possible. So, okay, we read this one. I thank you all for joining us, guys. If you are here, please don't forget to follow our pages across social media, AK Pokulo. If you're on Facebook, drop us reviews on our Facebook pages. If we've ever impacted your life and somehow, we have a lot of scammers and spammers leaving forex trading reviews on our Facebook pages. So please counter that. Go drop us. If you've learned anything or been informed or you've benefited in any way, or we've made your day better in any way possible, we would appreciate that. Guys, hopefully this is the first time I'm actually coming live this new year. Hopefully we're going to be doing more of this year, where every Friday we are likely to come live and answer questions and see how we can assist during these challenging times. So follow the page, please share the live video. Now immigration has become a do or die affair. You don't know who needs our help. So please share our video, and then your family member can benefit. Okay, so somebody says, do you advise someone transferring his case to different country for interview? Oh yes, we absolutely advise with that. It depends. Is it a non-immigrant visa case? Is it an immigrant visa case? Is it a diversity visa lottery case? Or what type of case? Each one has its own requirements, and we need to review it to give you the right advice. We're currently handling a lot of cases for immigrant visa appointments where people transferred their cases and they were subjected to 221G processing and fraud issues because they've realized that people are trying to circumvent lengthy wait times. Foreign Affairs Manuals, which is the Foreign Affairs Manual, the single authoritative law that guides visa officers about how they have to adjudicate visa cases. You are not allowed to just transfer cases to circumvent lengthy wait time. So if you do this, some of the consulates are complaining that Ghanaians are trying to transfer their cases and they're giving a hard time. So it depends on what your justification is. We'll review that and give you advice based on current happenings on the ground according to our cases, because we're helping a lot of people in such situations. So contact us and we'll see how best we can assist you, okay? All right. Well, thank you guys again for joining us, and don't forget to follow our pages, AK Pokulo. We're across, we're on all social media platforms. Now, because of mass deportation, people don't want to tell anybody their immigration status. You'll be walking around thinking this person is a US citizen, but they're not a US citizen. They're struggling. They need help. They need guidance or direction on who to go to. Because now some of the states are proposing bills, immigration bills are okay. If you report an undocumented immigrant, you can get $1,000 as payment. It's not yet law. It's not yet law, but these are some of the proposals that they are making. And so I'm trying to verify on, TikTok is just impossible. Okay. Yeah, it's not yet law, but there could be a law on that soon. So you don't want to tell your immigration status to anybody. It's the more reason why you have to share our information, because people may be looking for us. Okay. So share our information. I remember a schoolmate of mine, their sibling, I don't want to give too many details, but their sibling was looking for help in immigration. And he had applied for a preference immigrant category case. So he had come into the US on an F1 visa. His CVIS record was terminated. He was out of status as F1, and he didn't know his priority dates became current and applied for adjustment of status. But he had unlawful presence, and so he could not adjust. And one of a very good, a close family member died. They applied for a travel document based on the green card that they had wrongfully filed. And unfortunately, the case was denied, and he couldn't pay his last respects to his mom who had died. And it's unfortunate because this was an old classmate of mine, and the guy only contacted me after the fact because he didn't even know that this was something I was doing, and I was able to help him to some extent, and we're currently working on the case. And I thought to myself, if this schoolmate of mine had shared this video, her brother could have, or her sister could have seen this and sought the right help when they needed it. Later, it impacted her. So the information we're sharing is highly valuable. You might not see how valuable it is, but there are people there that might pick a line or two and that could change their lives, or their immigration trajectory in the United States. So please don't underestimate what we're doing. It's impacting daily lives. So share the video across your social medias and with people that may need help, because this is a very crucial time for a lot of immigrants in the US. Thank you all for joining. I'm so excited again to be back, but yes, we have to call it a day. I will see you guys in our next video. When you see our videos, please like, comment, share, so that our videos can reach all the corners of the earth. We have a message to share. Okay, thank you all, and I will see you soon in our next video. Bye, everyone. Take care. Thanks for joining. Bye, TikTok. Bye, Instagram. Take care. Oh, it looks like this didn't end. Facebook didn't end. Let's end it here.